Thank you all for joining us for Litigation Basics, episode number 3, Discovery Practice. My name is Stephen Reingold, and I am your moderator today. This webinar is part of the Financial Poise webinar series, Litigation Basics. Slide 6 of the slide deck summarizes this episode, and slide 7 provides a summary of the series. Speaking of the slide deck, you should understand that we will not step through it in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the slide deck handy, though, because I will try to indicate what slides our conversation is touching on as we proceed, so you can take notes. Our panelists today are Tim Pastor, a partner at Montgomery, McCracken, Walker & Rhodes, Adam Russ, an equity member at Gordon Arata, Montgomery, Barnett, Jeff Leon, a partner at Karen, and again, my name is Stephen Reingold, and I'm a partner at Saul Ewing. So now, we appreciate that you're not spending your time and money to attend this webinar. Sorry, a little technical difficulty there. We appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us. You can read more about us on slides 38 through 41. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to financialpoise.com or send an email to info@financialpoise.com with the word subscribe in the subject line. This webinar is being sponsored by the National Law Review. We thank you for your sponsorship. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand, or if you have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode, and we will do our best to get you an answer. Okay, let's get into our discussion for today. And Tim, I'm going to start with you. Like all of these webinars, we're speaking to folks who are likely new at litigation. And so discovery practice, is a very, very big part of what we do as civil litigators. But let's begin at the beginning, as we often do. Can you give our audience, please, a working definition of discovery, and tell us typically what is the scope of discovery in litigation?
Well, thank you, Stephen, and it's an honor to be presenting with you and Adam and Jeff. Discovery is a term that we lawyers use quite frequently because it arguably represents the largest portion of the case, or at least it has the capacity to represent the largest segment of the case. The word discovery suggests learning, it suggests investigation, it suggests uncovering information, and that's accurate. The discovery part of the litigation process is the pre-trial phase, where both parties get to seek information from the other in the form of often written discovery demands, interrogatories, document demands, requests for admissions, perhaps depositions, which are questioning a witness under oath pre-trial. These are all various discovery devices. And the opportunity is given on a reciprocal basis to get information from your adversary in litigation, the intent being have a full and fair opportunity to discover facts and assess the claims and assess the defenses so that you can make fully informed decisions about potential resolution or trying the case. Now, discovery, by its name, suggests that it's intended to learn information, but admittedly, sometimes we lawyers pursue discovery for the purposes of proving certain points. So there is this balance between seeking information and learning or discovering it with using it to your advantage in the course of the litigation to prove your claims or defenses.
Great. It's an excellent overview. Thank you. Adam, let's move over to you. So, and as we'll get into this, and we're going to talk about the different types of discovery, written and oral, that Tim touched on. We're going to talk about some of the rules governing discovery. But one of the things that we litigators deal with, particularly in the federal court system, is the concept of proportionality. What is it and how does it apply to discovery?
Sure. And thank you very much for having me on the panel today. The concept of proportionality in the context of discovery comes from Federal Rule of Civil Procedure 26B1, and it generally refers to the principle that the scope and extent of discovery should be balanced and proportional, quote, to the needs of the case, as the amendments to the federal rules about 10 years ago added in. That takes into account such factors as the importance of the issues that are at stake, the amount that's in controversy, the parties' relative access to the requested information and relevant information, the burden and expense of the proposed discovery that the party seeks, and then the importance that the discovery would have in resolving the underlying issues in the litigation itself. So in essence, proportionality aims to ensure that the discovery process is both fair and efficient, that it avoids undue burden and expense or delay, while simultaneously allowing parties seeking to learn more in the discovery process to be able to obtain information that may relate to either the claims or the defenses that are being lodged. Now, courts will typically assess proportionality through a case-specific analysis, where the court will weigh the relevance and the importance of the requested discovery against the potential cost and the burden that would impose upon the parties. And as we all know who do this regularly, discovery can be a very expensive part of litigation. And then this analysis helps to prevent discovery abuses by parties, such as where there are overly intrusive or overly expensive requests that really won't get to the heart of the matters at stake.
Thank you for that. As we talked about, we're going to use the Federal Rules of Civil Procedure as a guideline. Some state rules don't have that proportionality requirement. So, one takeaway for our audience is make sure you know your local rules, your state rules, and your federal rules if you're in federal court, because, it is often both a sword and a shield to use the proportionality requirement. But if you don't have it in state court, either it's established through case law or you have a different approach. Jeff, with that as a segue into our using the federal rules as our baseline and acknowledging that, state court practice is going to vary across the country. When you're in federal court and you're in civil litigation, what is the first phase of discovery? Nope, there he is. Okay. Looks like Jeff's having some technical.
My internet is freaking out. I'm trying to log in through the phone. I'm trying to get in through my phone. If you can let me in through there. Thank you.
Recording in progress.
Okay, let's try that. So just turn your audio on, we'll leave your video off, and we'll proceed.
Okay. All right.
There we go. Okay, so question again, just to repeat, we're using the Federal Rules of Civil Procedure as our baseline. As we've talked about, state rules may vary, but in federal court, what is the first step in discovery in civil litigation?
I mean, usually the first step is mandatory disclosures. There's a series of mandatory disclosures that you have to make in, that are listed in the rules. And, they're timed, to the number of days after a complaint is filed or a responsive pleading is filed. And the most important thing I would say about this is, while the mandatory disclosures are in the local rule, are in the federal rules, many district courts have very specific implementations of the mandatory initial disclosures. And, some of them are quite extensive, especially when you're in some of the rocket docket type jurisdictions. And if you're the plaintiff and you're filing a lawsuit, you need to know what you need to have in your hands on the day that you file that lawsuit, because you may have to make fairly quick and specific and occasionally extensive disclosures very shortly after filing your complaint.
Right, and for those following along, you'll see on the slide deck, the general federal rule is 26 Federal Rules of Civil Procedure 26A1, which lists the 4 categories of things that need to be included. Jeff's point is very well taken. Always check your local rules because they may vary greatly into what additional information needs to be submitted. So after initial disclosures, Tim, let's go back to you. We have different forms of written and oral discovery that you touched on. One of the most commonly used tools is a request for production or a request for inspection. Let's talk about that. Let's talk about the other forms. What is it that you typically see or use after initial disclosures?
Sure. So I know we're going to get into a little bit more detail on each of these and subsequent discussion. So very generally, let's talk about each category or of discovery device. So Stephen, you mentioned requests for the production of documents. They are also commonly called document demands or document requests. They go by various names. Those essentially are requests for your adversary to produce records in their possession, custody, and control that are relevant to the dispute. Of course, what is relevant to the dispute can often be a source of conflict between the parties, and that can be that can lead to motion practice over whether a sufficient number of documents were produced or whether the requests themselves are appropriate. But that's your first discovery device, requesting documents. And to be clear, when we refer to documents, we're talking about a very extensive definition. Typically, these types of requests will include definitions, and documents is often among them. Some courts delineate what documents means, but the point I want to make here is that it's not restricted to paper documents. In fact, as of now, at this point in world history, I would say that electronically stored information represents a much larger, in most cases, set of data that is requested and produced in response to these types of requests for production of documents. The second type of discovery device is what we typically call interrogatories. Interrogatories are simply written questions answered under oath. So they are distinguished from document requests in that they don't seek documents necessarily, they seek narrative answers. Sometimes those answers can be one sentence, sometimes it could be an extensive answer. They are intended to get at information. They are intended to bind the opposing party to those answers under oath. The third discovery device that is common are called requests for admission. Unlike interrogatories, which can often be open questions to be answered under oath, requests for admission are more targeted. They're more typically are supposed to be more narrowed. They're intended to establish certain predicate facts in the litigation that one party believes are not really or genuinely in dispute, and so they want the other party to admit them. It doesn't always go as planned. Sometimes the admissions are equivocal or not made at all, and there can be penalties for giving a bad faith response to requests for admission. So I don't use them in every case, but they can be very effective in select cases where the evidence on certain facts is quite clear and you want to get your adversary to narrow what the disputed facts are. This is a great device to do that. And then finally, the other discovery device that I'll mention is something that you would serve upon a non-adversary, or as we call a non-party, meaning you've got a plaintiff and you've got a defendant, but there may be others that have information that is relevant to the dispute, and those are non-parties. We don't typically serve requests for documents or interrogatories or requests for admission on them. Instead, we serve them with a copy of a subpoena. And the subpoena not only commands their cooperation, but it also includes typically a set of document requests that are directed to that third party with the intention that they gather information and produce it to you. This can also be the subject of conflict between the non-party and the party issuing the subpoena. because the non-party has certain rights to be protected from overly broad or unreasonable requests. But nevertheless, it is a discovery device. It's very, very important to seek information from non-parties in litigation.
Thank you for that, Tim. So Adam, let's move back to you. I want to walk us through each of these different types of written discovery vehicles before we get into oral discovery. So sticking with the first one, which was request for production. So let's talk about that in a little more detail. What type of documents are usually requested? And to Tim's point, document is almost a bit of a relic these days in terms of paper documents. We're dealing with electronically stored information. What types of electronically stored information or ESI are sought? What is ESI and what is it? How is it sought in discovery?
Sure. Just under Rule 34, I think there are kind of three buckets of information that can be requested by a party to have the other party produce. One are documents and correspondence that are in hard copy format. So you think about traditional file cabinets, things that would be in a physical format that you would find like in a file cabinet. Second is what we were just talking about, ESI, or electronically stored information. I'm going to talk about some of the categories of that in a second. The third, and this is one not to overlook, 34 also allows a party to request that another party to produce other tangible things. So that can be a key piece of equipment that's at issue. It can be a shoe that's at issue. It could be really anything that relates to the claims that is physical and tangible. So regarding ESI, the types of documents and correspondence commonly requested there, what you would find are things that exist in an electronic format, like emails, things that are in your Outlook or Gmail accounts, traditional Office, Microsoft Office type documents like Word, Excel, so spreadsheets, presentations, PowerPoint or other slide decks, PDFs, also other scanned image formats. So if you've got physical documents that you then convert into an electronic format and your scanner produces them not as a PDF, like it's a TIFF file or something like that, those are also discoverable. Their digital documents can be discovered. Other types of documents that often will be found in electronic format include financial records. So financial documents like bank statements, tax returns, general ledgers, payroll records, things like that. Particularly important in cases involving employment disputes where there are wages and hours of a plaintiff involved. Those will commonly come up. They'll also come up in business divorce cases where you're talking about valuation and the financial records of an underlying company to try to figure out what the actual damages are. Another big category of electronic documents these days are medical records. Often in personal injury cases, you've got a vast array now of electronic medical records, EMRs, that are out there from providers that you may need to go out and seek through subpoenas to these third parties. Also talked about wage and hour and payroll records, but a broader category of that, of course, are just generally employment records. So employment records of parties that are in dispute. So things like the personnel files or performance evaluations, any sort of employment contracts that were played, disciplinary records, things like that. Couple other key things that we may see in electronic format. Besides just emails, think about text messages, think about social media content, think about other types of information that's transmitted with cell phone devices these days. A lot of times it's not just typically text messages or emails anymore, but we're talking about platforms like Teams or Zoom and things like that where people communicate. All of those fall under the general electronically stored information umbrella. And it's not just if they're on your client's laptops or on their servers, but you also have to look at cloud storage these days, because here we are in 2025. A lot of this ESI is being stored in the virtual cloud through things like OneDrive, Dropbox, Google Drive, things like that. So wherever this ESI is found, you've got an obligation to go out and figure out what your client has, and when requested, produce it in discovery when requested.
And I'll just add a footnote to that. We could do a whole hour on ESI And, one of the things that, our newly admitted lawyers who are listening should be aware of is that we are obligated under our various state rules of professional conduct to be technically proficient in these various platforms and programs in order to be able to deal with them in discovery. So, you have to know how Slack works. You have to know how Snapchat works. You have to know that unless you disable the feature in Snapchat, messages will disappear after 30 days. And you don't want to be standing in front of a judge explaining why something was accidentally deleted because you didn't have your client turn that off. So there's a lot of nuance electronically stored information, a little bit beyond the scope of today, but again, we could do a whole hour or more on it. Jeff, let's move over to you. Let's say that Adam is your opposing counsel. With all the knowledge he's just shared, he has served a request for production on you as opposing counsel. What do you do in preparing to respond to and in responding to a request for production?
So it depends on what type of client you're representing, right? If you're representing an individual, you need to make a list of likely relevant places to look for information. Sit down with your client and have them gather it. So, for example, if they have to gather their own bank statements, if they have to gather their medical records or bills, whatever it is, and you have to have a conversation with your opposing counsel about the form that they want it in. Sometimes just getting, PDFs of electronic documents is fine. But other times they will want the document in what's called its native format. And that means, for example, instead of printing out a Word document, they're going to want the metadata associated with the Word document that may show, when it was created, who edited it, when, all those sorts of things. And then you have to agree upon a method of transmitting that and storing it, to them. With individuals, this is less likely to be an issue, but when you're representing businesses, it's a much bigger issue. And when you're representing a business, you're going to have to talk to whoever, the IT person is, who's in charge of the storage of electronic information. And you're going to have to learn from them every single source of electronic information that exists. A lot of companies use internal chat platforms, and you got to know what they have and how long they've kept it, and you got to know their cloud storage and how long they keep it. There are even companies that still store things on data storage devices that aren't physically in the cloud or something. They're sitting in a warehouse or something. You've got to figure this stuff out. You got to figure out if the company even permits people to keep paper copies. Some companies will literally, every few months visit an office and make you purge paper copies because they don't ever want to deal with that in litigation. And the view is that unless you have it, for your immediate need in paper, you don't need to store it in paper. It's already stored, electronically someplace else. If there are multiple copies of a document in hard copy, you may have to produce the multiple copies if people have made handwritten notes on those copies, right? Even though they're identical, they're not identical if they have handwritten notes. There's a whole series of considerations that you have to have a game plan for before you jump into the process of gathering the information that's collected. So you have to be very organized. You have to know, generally what to ask, and you have to be relentless in tracking it down. I will tell you, if you're representing an individual and they tell you, oh, I don't have Snapchat, and it turns out they do have Snapchat, for example, that doesn't look good in front of a court. It could even get your client sanctioned, those sorts of things. So don't always take your client's word for something. If some social media is going to potentially be relevant, you can check, right? There are ways to look for a person. on their websites and profiles, etc. For larger cases, you're going to need to have a vendor that will help you gather and store the ESI, the electronically stored information. And they will help guide you. And frankly, in many cases I've had, we get our ESI vendor on the phone with the other side's ESI vendors, and they talk for like an hour or two, and we all sit there with our mouth open drooling because we have no idea what they're talking about. They're not even speaking English. But the point is, you got to do stuff like this in modern day document discovery. So I know that's a lengthy answer. And as Steve said, we literally not only do a whole hour on ESI, we could do a day. And there are, in fact, seminars that are entire day long on this stuff. It's that integral to the practice of law in 2025.
Yeah. And to Jeff's point about, understanding what your clients have, having a custodian interview and a custodian questionnaire that you can walk through each of the data sources, custodians, locations, gives you that roadmap when it comes time to collect. Tim, let's move back to you because we do have some other discovery vehicles we want to get through in our remaining time here. When you gave us the overview, one of the other vehicles you mentioned was interrogatories. So you gave us sort of the 30,000-foot view. Let's drill a little deeper. What do you typically hope to accomplish when you serve interrogatories on behalf of a client?
Well, as I noted earlier, the concept of discovery can include seeking to learn information that you do not know. It can also include seeking to prove certain points regarding claims and defenses. And the interrogatories can help you fulfill both of those purposes. So if you serve interrogatories with the intention of learning certain information, certainly you can use it for that purpose. But you also may ask questions knowing that your adversary is going to struggle to answer them without perhaps implicating themselves some way. So interrogatories can serve that purpose too. Now, under the federal rules, interrogatories are limited. I believe you get 25 interrogatories. That expressly states that it is exclusive, inclusive of subparts. This is an area that leads to some conflict as well, where a party includes subparts, and sometimes parties will object and say, well, you've ultimately served more than 25 interrogatories if we count your subparts. And there's actually case law governing what a court deems to be a subpart or not a subpart. So it can get quite granular when you're talking about these limitations in how many interrogatories you can serve. And the intention of the limit is to recognize that the parties are also entitled to take depositions, which we'll talk about in greater detail in a moment. And so sometimes the questions that you're posing in interrogatories are better suited in a deposition. And that can lead a party to object to certain interrogatories, including subparts, or to claim that too many have been asked. And it doesn't mean you're without the information. It means you may just have to follow up in a deposition. So the purpose of the interrogatories, other than the two that I identified, is you're trying to learn identities of possible witnesses, background information about those witnesses, what they know. You're trying to get greater detail if you're a defendant, for example, on the plaintiff's claims, and have a better understanding of what they're actually alleging. Or if you are a defendant and you've served interrogatories on a plaintiff, let me reverse that. If you are a plaintiff and you've served interrogatories on a defendant, you may want to better explore their defenses. And so interrogatories give you the opportunity to do that. There are also things known as contention interrogatories, where you're trying to understand, you're trying to get your adversary to either disclose or take positions on narrow issues. Again, I think this crosses over a little bit into the request for admission, so I don't use that device very often. I would use interrogatories for more open-ended types of questions where I want some degree of narrative answer, whereas requests for admission I would target more specifically. But again, these are interchangeable. It depends upon the jurisdiction you're in, whether to use contention interrogatories or requests for admission, or whether you can have a certain number of interrogatories beyond the federal limit. I should point that out, that we're, again, as a reminder, talking about federal limitations, whereas some states may not have limits on how many interrogatories you can ask. So it does depend upon the jurisdiction, your method of practice, and your strategy as to how you use this particular discovery device known as interrogatories.
If I can add one thing, Tim, because I think it's important. It's not the case in most federal courts. It can be in certain localities in the local rules, but certain states have what are called form interrogatories, and they are literally a series of interrogatories that are already written that you can just pull up and propound. And some are even very specific. Oh, it's a personal injury case. There's a set for that. And they usually don't count toward the limit in the numbers when you use the form interrogatories. So that's just something to keep in mind. And it's a big theme throughout all of this. We're talking about the federal rules because that's common for everybody on this call when you're in federal court. But the state rules are very different, especially when it comes to discovery. And
Right.
you have to know what your state rules have and what your local rules have. And even in federal court, the differences from district court to district court can be very meaningful.
Right. And the other thing you'll want to check in your district court rules and your state court rules is sometimes there are uniform definitions for discovery requests. We talked earlier about, Tim mentioned documents, the term documents and how broadly it's defined. When you're serving discovery requests, you want to check to make sure that your definitions are consistent with what is required in your jurisdiction. Adam, let's move back to you. So Tim has now told you why he has served you with interrogatories. What's your approach to answering Tim's interrogatories?
Sure. When approaching interrogatories, I think it's essential to adopt a strategic and thorough approach so that you provide both accurate and complete information in the responses and objections. So first thing I do when I receive a set of interrogatories that's been propounded upon my client is I read through them, try to really understand what the interrogatories are looking for. And I try to determine whether I can lodge any effective objections first to those interrogatories. I also will have a call with my client to go over and discuss the interrogatories so that they really understand what it is exactly we're looking to the other side's looking to try to discover here, and to discuss strategies about how we can go ahead and respond. When we have that call, we want to talk about, who are the client's key custodians who may have information that's responsive and relevant to the requested interrogatory. Once I get that information from the client, then we move to the next piece. And that's really where you go and you start to organize what you've got. And you try to set it up so that you can provide truthful and fully complete interrogatories, along with those necessary objections that adhere to all of the requirements of the court, whether it be state or federal court and district to district, along with any of the applicable procedural guidelines that may be in play. There are some circumstances, depending on the sophistication of the client, I'll let the client provide a first draft of the interrogatory responses. I actually won't draft that, or won't have our team draft that. We'll instead rely upon the client to give those responses. Other clients, though, they need a little bit more hand-holding. So I'll work with them, and as I'm reviewing through the information that they've provided, I'll have another call with them to talk about the responses, create a draft, circulate that draft to them so that they can then go over it and ensure that everything is both truthful and accurate and complete to the best of their knowledge and information. You always want to ensure that the client's being honest and forthcoming with the information that's being requested. Again, you can never underscore just how important it is to make the objections that are necessary to a request, because in many jurisdictions, if you don't object properly and timely, you can waive that, and you can create a lot of headache for yourself and your client in the future. So you want to go through your interrogatory responses again a second time before you've got everything in final form, and just make sure that you've got all of the proper objections, you've broken everything down, and you're taking everything into account so that you're not leaving anything kind of off the table before you finalize those responses. Again, you've got to get the responses once they're kind of in a final format to your client, because there's a verification requirement in most jurisdictions that interrogatories need to be reviewed by the client. They need to sign a verification that says that the information that's been provided is to the best of their knowledge, information, and in corporate settings, that there's a corporate custodian who's reviewed this and has indicated that the information upon which these interrogatory responses are based come from the corporation's knowledge in compilation, not from just one particularized source, because that's often the case. I also, before I hit send and submit this out to the other side, review it again for any errors or inconsistencies, and look for any kind of corrections or clarifications that I may need to do to update those initial disclosures that we talked about under Rule 26 earlier.
Great, thank you for that. So our last written tool before we get into oral discovery, Jeff, let's move back to you just real quick, just watching the clock here. Tim touched on this very briefly earlier, but what are requests for admissions?
Requests for admissions ask the other side to admit certain things are true or are not true. And they can be useful devices. If something is very simple, if it's not, you're going to end up with some complicated wording request for admission that they're going to easily be able to object to or give an evasive answer. So your best bet is usually to try to nail that down through depositions. I think the real usefulness of a request for admission is in getting evidence. Admit it. Admit that this document is authentic. Admit that this document was prepared in the regular course of your business. And by the way, the one thing we haven't talked about at all with regard to discovery that bears mentioning, only in the shortest form, is you have to know the rules of evidence when you are taking discovery in any form, right? You got to make sure you're getting things in a form that are going to be admissible at trial. And that may require follow-up, right? So you may get the document, but the document's not going to be admissible until you get some testimony from somebody saying it's not a hearsay document because it fits into, say, the business records exception to the hearsay rules, or it constitutes an admission against the interest of the party that created it. But you have to establish the requisites for that. So you have to know the rules of evidence.
All right. So, and obviously another hour easily we could do, but Tim, let's just stick on requests for admissions for just another moment. So there are clearly some advantages to serving requests for admissions. Any risks serving requests for admissions?
Well, the first risk is that your adversary may be shameless in their response and not give you the the answers that you're looking for. Now, there is a way for you to address that, and that is to follow up and argue that they answered in bad faith, and there can be penalties depending upon the jurisdiction for that. There's also a risk to the party who's responding to them if they don't respond within a certain amount of time. I believe under Federal Rule 36, they get 30 days. So if they don't respond within that time, the risk is that those would be deemed admitted. I have a case like that right now, not in federal court, where our adversary did not respond to requests for admission. We followed up 3 times, which is arguably not necessary, but is prudent, so you can represent to the court that there's really no excuse for their failure to respond. And we're now drafting a motion for summary judgment, suggesting that we should get judgment as a matter of law because the key operable facts are deemed admitted. We're also presenting evidence as to why, even if they're not deemed admitted, we're entitled to summary judgment as a matter of law. But this is a good example of using a discovery device for strategic purposes to either get the admissions that you want, or in our case, get a non-participating adversary to render them admitted because of their failure to respond. And I can get into why they didn't respond, but that's beyond the scope of our presentation today. The point is, you can avail yourself of these powerful rules when that happens.
Absolutely. All right, we've talked a lot about written discovery. In the 20 minutes or so we have left, one of the other two topics I'd like to cover is oral discovery. And so, Adam, let's throw it back to you. High level, what are the basic rules in the federal rules of civil procedure governing depositions?
Sure. Depositions are governed by Rule 30 of the Federal Rules of Civil Procedure. And for those in the call who don't know what these things are, depositions are essentially an in-person, or in modern times, a virtual ability to obtain sworn testimony from witnesses, where you have essentially a conversation on the record with a witness about the issues that are in dispute in the case. And that can be both party opponents and as well as third-party witnesses. Now, basically, the deposition process begins first with a notice. Party seeking to depose a witness has an obligation to provide a reasonable notice to all of the parties involved, so that all of those parties can be there and present for the deposition when it takes place. The notice has to include certain information, including when, where, and how any recording is going to be taken of that deposition, so that the deposition transcript can be used in subsequent proceedings. Now, a notice of deposition is given for a party deposition, while for non-party or third-party depositions, you have to get that by compelling the witness to attend through a Rule 45 subpoena. And that's something that we'll talk about a little bit later.
Okay.
Once you're there on the day of the deposition, whether it's in person or virtual or over a telephone even, before the witness provides testimony, she or he has to raise their hand and swear under oath and affirm that the information that they're going to provide during the deposition is the truth, the whole truth, and nothing but the truth, similar to the testimony that's given in court and what you'd see in TV shows or movies. This is one of the rare instances where they actually do get it right in those shows.
Mm-hmm.
Oftentimes during the deposition, you're going to have a method of recording. Typically, that's been done through stenography, or a human stenographer who is there taking down every word that's been said. But you can also do that via a video record as well, where you want to preserve and see the deponent for use at trial in the future. Now, during the deposition, once the witness is sworn in, the party who's taking the deposition asks questions to the other side, to the deponent. The deponent there has to listen to the question. The defending attorney can lodge any objections that may be relevant to the question that's being asked, but oftentimes, unless there is an instruction not to answer, the witness still has to go ahead and provide a response on the record. You then can take any of those objections up at a later time with the court. It's important to note that a failure by a defending attorney to object to a particular question or a line of question that's been raised during the deposition may result in actual waiver of that later when you go to take it up with the court. So you have to be on your A game during depositions and ensure that you are doing your best to protect the interest of your client when those questions are being asked that are objectionable. If you don't, it's one of those things, you snooze, you lose.
Mm-hmm.
Depositions can last, federal rules allow up to 7 hours for deposition of witnesses, not including periodic breaks or lunch and things like that, or conference periods that may occur. The frequency of how those occur during a deposition kind of vary from deposition to deposition and jurisdiction to jurisdiction, depending on the needs of the deponent and the parties. And remember that this deposition testimony that is being taken is not just to learn more about the case. It's not just pure fact gathering. The deposition itself, once it's been properly transcribed by a court reporter, can actually be used as evidence in trial, as Jeff was saying, under the federal rules of evidence, for various purposes, like impeachment of the credibility of a witness, for refreshing a recollection of a witness who, seems to have forgotten when they're up on the stand, or in some circumstances as substantive evidence if the witness is unavailable to testify in person. And that may come up. And that's one of the important reasons to ensure that you have taken a deposition of an important witness and you've preserved that testimony through a recorded transcript.
All right, let's pick up on that last point, and I'm going to go back to you, Jeff, because that's a really important point. Is, there's no typical case, obviously, but depositions are such a critical component of discovery. What is it when you take a deposition? What are you hoping to get out of that deposition for your case and for your client?
Me?
No, Jeff, that's for you.
Oh, okay. I'm sorry.
Yeah.
I mean, you're trying to establish the elements of your claim, right? And so you have to know what the law is and what you need to establish to win a trial or to defeat summary judgment. And one thing I tell young lawyers all the time, because I see this happen, a lot of people think a deposition, it's just, it doesn't matter that much. A deposition can become the testimony if a witness is unavailable, as that is defined under the various rules, right? You can't compel them to come via subpoena to trial, or they die, or have a medical excuse, whatever it is, that transcript, you're stuck with that. So while there is a discovery component to a deposition, there's also a trial component. You can't just mess around. You have to, especially if you know that a person is going to be, more than 100 miles from the courthouse in federal court. You have to treat that almost like they're on the stand and you're going to make your case to the jury. Illinois provides an interesting counterpoint to that, where you can notice up 2 depositions. One, a discovery deposition, just to learn whatever they know. And then you can notice up a second one later when you know everything, and you can take that very precise, detailed evidence deposition is what it's called. But I have seen cases literally fall apart at trial because the depositions taken were unusable. The questions weren't good. You have to cut them up and move things around to try to make them make sense and flow. So it's crucially important that you attach a deposition in a very organized way. So learn what you need to learn. But then if you think there's a pretty good chance that witness isn't going to be a trial, you have to ask ultimate questions, which you often want to avoid in depositions. Not because you don't necessarily want to, give a roadmap to opposing counsel as to where you're going, but sometimes you really have to. So, and you also have to lay the groundwork for admission of the document into evidence. It's not enough to just learn, okay, this is what you meant when you said X, when you wrote X in the document. You have to establish that they received it in the regular course of their business, that it was maintained, as part of company policy, regularly maintained, stuff like that. You have to do those things. It's boring. You have to ask those questions sometimes literally 50 times in a deposition, every time there's a document. Unless you have some agreement going in beforehand with counsel that any document that was produced by them from their files is a business record and they're not going to fight you on that.
Right.
So, what you need to get out of a deposition is as varied as every type of case in every factual context.
Absolutely.
That's why I'm talking about these broader strategic, objectives.
Right. Last question about depositions from parties. And Tim, let me go back to you. In civil litigation, often parties are not individuals. We touched on this earlier. They're entities, they're companies, they're businesses. What if a party is an entity? It's not an individual. You want to take that party's deposition, but you don't know who's going to be the deponent. You don't know who knows what. What do you do under the rules?
So in that circumstance, Stephen, what you'll do is you'll seek a corporate designee deposition. In federal practice, we refer to it as a 30B6 deposition because that's the applicable rule. Your intention is to identify a series of topics on which you would like testimony, and you then defer to your adversary to designate an appropriate representative who can testify intelligently on those topics, either because they have personal knowledge or they have knowledge imparted to them by the entity, or they're really their colleagues, or by a review of files kept in the regular course of business. So what a lot of people misunderstand about this process is that the witness themselves may not have an abundance of personal knowledge, but may be offered up by the corporation or the entity for purposes of testifying because they deem that person credible or astute or authoritative. Well, that's all good. Those are good reasons to choose that witness to be your corporate designee, but they still have to have enough information imparted to them for purposes of answering the question. So in these circumstances, you are not without recourse. You can seek a 30B6 corporate designee deposition and bind the company to the answers of the representative or representatives, because I should point out that when you identify topics for which you want testimony, the opposing party has the right to designate multiple witnesses who can answer specific topics. And of course, you can challenge whether that's appropriate. They can challenge certain of your deposition topics. There can be disputes that emanate from a 30B6 notice of deposition. We can address that another time. Ultimately, this discovery device does give you access to information held by the corporation or entity against whom you're litigating.
Thank you. And yeah, that is a whole another area, pardon me, that we could spend an hour on there as well. All right, we're closing in our last 10 minutes or so, and I want to talk about two final things. Just Adam, really, really briefly, we touched on this earlier. What about discovery from non-parties? What are the devices used to get discovery from non-parties?
Sure, non-parties are often so vital and important to a case, sometimes in some cases, even more so than the party's own testimony themselves. Discovery from non-parties is possible in litigation under certain circumstances in conjunction, like we said earlier, with Rule 45. And you can seek both written and oral discovery, including depositions, from non-parties through various legal mechanisms. The most important one, of course, is this Rule 45 subpoena. Now, keep in mind that specific procedures for properly serving a subpoena will vary depending on the jurisdiction and the rules that are governing the case. So that's important to know. And also know that if you're in arbitration or mediation, there may be other rules and procedures that apply there as well. You may not have the same type of subpoena enforcement power that you have like in federal court. Now, when a non-party is served with a subpoena, the non-party has an obligation to respond both fully and truthfully to the request, just like a party does. Note, though, that a non-party may seek a protective order from the court that limits or prevents the requested information, or at least some of the scope of the requested information, either in whole or in part. So the overarching notion of proportionality that I talked about earlier today also applies to these Rule 45 subpoenas and requests for this information from these third parties as well.
Okay, great. So we've spent almost a whole hour talking about fact discovery. I want to pivot very briefly into expert discovery. And then if we have time, I want to talk about what happens when the discovery process breaks down, when there's an impasse. So Jeff, let me throw it over to you for just a really, really short answer. Just give us a real brief overview of expert discovery and how it differs from fact discovery.
So experts you need for things that are beyond the common experience of an average person. And, they're often highly technical, but sometimes not. In a personal injury case, it can be somebody who's expert in accident investigations. And the main differences with an expert is they're allowed to offer opinion evidence, whereas recipient witness testimony, people who have observed the things, they're not allowed. Their opinion's irrelevant. And they're allowed to rely on inadmissible evidence, like hearsay, in order to form their opinion. It doesn't mean that evidence comes in, but they're allowed to do that. And then there's a process to get them qualified as an expert by the court, which, again, could be the subject of a 3-day seminar. But I mean, in the quickest possible way, those are the main differe's.
Okay.
And they are subjected to discovery themselves. They have to prepare a report, setting forth their opinions, supporting data. There's a deposition that occurs, and then there may be a motion to exclude that individual. So there's a whole separate set of discovery procedures that relate to the use of experts.
Okay, and so Tim, picking up on something that Jeff just mentioned, expert reports are such a big part of expert discovery. Walk us through a little bit about the preparation of an expert report and the disclosure of that report to the other side.
Sure. So it's very common for the attorneys litigating the case to confer closely with the expert and help them develop their opinions. Of course, in some circumstances, the attorneys can chart out that report for the expert. Ultimately, though, the expert has to sign their name to the report, and so it's their opinions that should prevail. And the attorney's job is to provide them with the necessary information upon which their report can be based. That typically requires that the expert identify the information that they reviewed in consideration of their opinions. They have to map out their opinions in a written report, although that does depend on jurisdictions. There are some jurisdictions that do not mandate written reports. And the report ultimately has to be sufficient to justify the expert's opinion. So, for example, if they take a position or offer an opinion with no substantiation for it, they will be subject to cross-examination. Their credibility can be undermined. And so counsel in the case is charged with ensuring that that doesn't happen, that the experts are credible, that they make certain representations based on the evidence presented to them.
Right. Adam, last question about expert discovery. And to my mind, one of the most fun things about what we do are taking expert depositions. I enjoy those more than almost anything. So what's a typical expert deposition like?
Sure. An expert deposition is often a lot more technical and kind of nuanced than your traditional witness deposition is for a number of reasons. As Tim was just pointing out, experts have a requirement to produce a report. Your expert deposition then essentially takes and looks at the information that's included in that report, and it tries to kind of tear it apart and learn a little bit more about what's inside that report. And what you're looking for in that report and in the testimony that comes out during the deposition are typically about 3 different things. One, the expert's underlying opinions that she or he reaches that relate to the claims and defenses at issue in the case. The second is how that expert gets there. It's the methodologies that are used. And these methodologies are really important because what you're trying to do is you're trying to poke holes in the science, the logic, the leaps from point A to point B that an expert takes to go from essentially factual information to opinion rendered based on those facts. And then the third category that I think of when I think about expert depositions are to look at the facts and the scientific bases that are being used. One of the things that experts have to disclose is, if they've relied upon outside sources and, third-party learned treatises and things like that as a basis for their methodology and for their ultimate opinion. You want to go in and take a look at that and make sure that they're being true to the science, that they're being true to the literature, that they are actually applying what is, industry custom and practice, as, those words are commonly thrown about, to reach that ultimate opinion. Because what you're trying to do through this deposition of the expert is you're trying to chase down the credibility of the opinion that's being reached. Is it credible or not? Is it founded upon, junk science and bad facts, or is it really founded upon good facts and good methods that other well-studied, learned individuals in that profession or in that particular area of expertise are themselves using? And if so, well, it's likely that the court's going to take a look at that expert with a lot more favorable viewpoint than they would one that's not.
Great. Okay. Last topic, just we're almost out of time. I've got one more question each for Jeff and Tim, and then we'll wrap up. So, Jeff, we're assuming all along everybody is participating in good faith in discovery. Very, very briefly, what happens when that is not the case? What's typically the first step you take if you have a dispute regarding discovery?
So virtually every jurisdiction requires you to meet and confer with your opposing counsel before you ever go to the court. And you can get tossed immediately if you don't do that. So it can be via writing, back and forth. You can jump on the phone. You need something to document what you agreed to or didn't agree with on the phone. And you have to reach a point of impasse. And then you can file a motion to compel or a motion for a protective order, depending on whether you're the seeker or recipient of the discovery. And the court will apply the law and the rules of evidence in order to decide whether the discovery has to be responded to or not. So that, in short order, that's the process.
Okay. And then, so Tim, final question to you. So the motion to compel has been filed. What relief can a court grant if a party is not participating in discovery in good faith?
So a court can do a number of things. First, it can order them to produce the documents by a date certain. Second, the court could sanction them. For example, monetary sanctions, force them to pay the attorney's fees of the party that brought the motion to compel. Another possible sanction is to strike one or more claims or defenses. So if it's a defendant, for example, who's failed to cooperate in discovery, a court could sanction them by striking one of their defenses. So the court has various options available to it to ensure that the parties abide by their discovery obligations. But of course, the issue has to be presented to the court, and the court has to be sufficiently brave to take those more drastic measures, provided they are in the best interest of justice when dealing with the discovery dispute.
Right. And I will tell our audience something that all of you are going to hear throughout your career, and we've all said, the four of us, a number of times: judges hate discovery disputes. So to the extent you can, in your meet and confer that Jeff mentioned, work out as many of the issues as possible, narrow as many of the issues as possible, it better serves you, particularly if you, whether you're the moving party or the responding party. Okay, we have 2 minutes left. Just a real quick roundtable. Final thoughts on discovery practice. Adam, let's start with you.
Sure. Discovery is far and away one of the most expensive pieces of the case, but it is vital for your client, because if you don't go through the proper discovery process, the last thing you want to do is show up to court, whether you're on the plaintiff or defense side, empty-handed or without the information that your party needs to succeed. And so it's very important that you go through the process, that you discuss with your client the importance and the value of investing in discovery, even though it comes with a cost and takes a lot of time, and both time and money, in order to do it right. But without doing so, they're not going to get the outcome ultimately that they seek.
Excellent. Jeff, final thoughts about discovery practice.
So the main difference between being a litigator and a trial lawyer is a litigator takes discovery without a view of how it's going to be used and its impact at trial. A trial lawyer is seeing all the way through to closing statements and is planning discovery accordingly. And I can't tell you how many times in my career I have seen litigators taking discovery and you can tell. You know, if you prepare a case for settlement, you may not settle because the trial lawyers on the other side are going to see you've prepared the case for settlement and it ain't going to work at trial. So you got to take a long view of where you're going, right? You have to look ahead. And as a young lawyer, it's really hard to do this on your own because you haven't tried a case yet, right? You haven't been through that, which means you got to rely on your older folks and ask, why are we doing this? And start to learn and get that sense. That's the most crucial bit of advice I honestly can give. Because all the details you'll pick up, right? I mean, it's just the nuts and bolts. It's the
Excellent.
big picture.
Tim, final thoughts on discovery practice before we conclude?
The practice of law is inherently deliberative. One of the best aspects of it is that we get to confer with smart people and come up with tactical and strategic plans. And that exists no more than it does in discovery. Discovery is a great opportunity for you to connect with both colleagues and clients and co-counsel and devise a plan that is very forward-thinking, as Jeff is suggesting, so that you can get the best result for your client.
Great. Well, gentlemen, thank you all for your time. To our audience, this concludes today's webinar. We thank you for joining another entertaining and we hope educational production of Financial Poise. Thank you all. Have a good afternoon.